Good morning, good afternoon, and good evening to all of you who have joined us today. We are at the very interesting panel on the ICC and Beyond, Reevaluating the Promise of International Criminal Justice. My name is Priya Pillai, and I'll be moderating this session. I would first like to thank the American Society of International Law for this incredible virtual conference in these very difficult and trying times. For this session, I'd like to thank the World Justice Project for sponsoring this incredible panel. And let me sort of go immediately into this incredible distinguished panel that we have today, and let me introduce them to you so that you know who's going to be discussing the intricacies of international justice and international criminal law. So to start with, we have Catherine Marquiuel, who is the head of the UN International Impartial and Independent Mechanism for Syria. She has more than 27 years of experience, including working as a judge in France, an international judge at the UN in Kosovo and Cambodia, as head of chambers at the International Criminal Tribunal for the former Yugoslavia, and as the ombudsperson to the ISIL, Daesh, and Al-Qaeda Sanctions Committee. Next, we have Charles Jallow, who's a professor of law at Florida International University and a member of the UN International Law Commission, where he has served as chair of the drafting committee during the 70th session and as rapporteur for the 71st session. He has published extensively on issues of international criminal law, with his most recent work being a Cambridge monograph on the legal legacy of the Special Court for Sierra Leone. Charles currently chairs the panel of experts on the election of the ICC prosecutor. Stephen J. Rapp is a distinguished fellow at the US Holocaust Memorial Museum's Center for the Prevention of Genocide. He is also senior fellow of practice at the Blavatnik School of Government at Oxford University and chair of the Commission for International Justice and Accountability. From 2009 to 15, he was ambassador at large, heading the Office of Global Criminal Justice in the US State Department. Previously, he was the prosecutor of the Special Court for Sierra Leone from 2007 to 2009, and from 2001 to 2007 was senior trial attorney and chief of prosecutions at the International Criminal Tribunal for Rwanda. Lorraine Smith Van Lin is an international justice expert who currently works as a consultant in international law and human rights. She has most recently worked with the international human rights NGO Redress as a post-conflict justice advisor, focusing on victims' rights, reparations, and transitional justice. She previously worked as the director of the International Bar Association's Hague office, responsible for monitoring the ICC as part of the IBA's ICC program. Prior to her international assignments, Lorraine has served for many years as a senior prosecutor and a parish court judge in her native island of Jamaica. So there you have it, an incredible panel and a really packed agenda, which we are going to try to get through in 1 hour. Just in terms of the layout of the session, we are going to address some of these questions and unpack the session in 3 broad strokes. One will be on sort of taking stock. Where are we right now? The second part will focus on accountability towards victims and where, again, we are in terms of the international criminal justice realm. And we will then address current challenges and what the issues are at this point that are pressing. So without further ado, let's start the discussion. So let me go straight to the issues of taking stock. Where are we? How far is the ICC? What has it done at this point? Are we looking at a turn to domestic law? Is that inevitable? Are we looking at regionalism? Are we looking at new mechanisms as well? So I'll kick off with a question first to Lorraine. Lorraine, if you could, tell us a little bit about your assessment in terms of the role and the functioning of the ICC so far, and a bit of a controversial question: has the ICC failed victims of core international crimes?
Thanks very much, Priya. And I first of all want to say thanks also to the American Society for International Law for this amazing opportunity to be part of this panel and to be, among such distinguished fellow panelists. I just want to preface any statement that I make about victims against the backdrop of today, and that is the International Day for remembering victims of torture. And I think that is a good place to start because it reminds us of the purpose of the ICC. It tells us why the ICC was established, to address atrocity crimes suffered by persons who have experienced some of the most egregious crimes in the world, international crimes. And when we talk about this institution and where it is now, I think we probably should add some figures so that we understand when we're talking about a court that is now an older teenager, and it has done 27 cases. Well, there are 27 cases on its docket, 34 arrest warrants issued, but the court has had so far 4 convictions. And I don't include in that number the high-profile conviction of Jean-Pierre Bemba, which was overturned. You can understand why for victims and for other stakeholders, there is a sense that although this institution is set up with lofty aims and lofty goals, it doesn't seem to be functioning as was envisaged. So I think I will put that as sort of the backdrop to my comments. My comments also will be basically, I think the FIDH report, which was issued just a few days ago, encapsulates what I think civil society and many other victims are thinking about the ICC at this time. And I will quote them because I think it's important. Essentially, they're saying the International Criminal Court is in trouble. The very foundations contributing to its establishment in 1998, namely multilateralism and a firm belief in international law, are being undermined by an increasing number of populists and despots. But while they point to that, what they see as some of the greatest challenges that the court is facing, and certainly this is from the victim's perspective, because this report was informed by a consultation which took place in Nairobi with the Kenyan Human Rights Commission, with a number of victims and other civil society organizations who are ICC situation countries. Their feeling was that while there was a threat from the outside, the threat from the inside seemed to be greater. It was really interesting to read how victims perceived that. And from my own experience, some of the greatest threats that the victims seem to feel about how the ICC is functioning now can be summed up in, I think, maybe about 5 sentences. 1, there is a sense of dissonance between what the ICC goals and aims are in relation to victims and what is actually being realized on the ground. We can pick any case to discuss that, I think, a little bit further. We can think of the Kenya context. We can think of the Laurent Gbagbo case, Laurent Gbagbo and Blake Ude from the Côte d'Ivoire. We can think of the acquittal of Jean-Pierre Bemba. The second issue is the process by which victims are able to engage with the court. There is also that sense that the court is seeming more and more distant from the population that it's intended to serve. And I know in the early days when I was monitoring the ICC, there were efforts by the court to have trials in situ and to actually physically go to where victims were. We've seen over time that for a number of reasons which I think have been exacerbated by the COVID-19 situation, the court seems to be even more distant. And I want to be clear that we are not here apportioning blame. We're not here saying that this is entirely due to the court's officials or the court staff, because we've seen efforts on their part to try to engage with the victim population. The question is it working? From the feedback that we're reading in the FIDH reports issued by Human Rights Watch and others, we are getting the sense that the gap is increasing. The third issue is the question of information provision to victims and the stage at which this is being done. So for example, the question of information provision at the preliminary examination stage. We know that for many years, preliminary examinations carried out by the Office of the Prosecutor was very much shrouded in secrecy. And then there was strong push from stakeholders, from civil society organizations to have that process clarified, more public, more transparent. That led to the prosecutor publishing annual reports. And that's great. The issue is there engagement with the victims at that phase of the process? The decision that of the pretrial chamber in relation in the situation in Palestine was an excellent step in that direction, where the judges basically mandated the registry to engage and to inform the victims from very early. What are we seeing in practical terms? The registry is saying for security reasons, and we can understand that. This is the reality of the context that the ICC is operating in. The information provision is, again, pretty much limited to what they provide on their website. So what we're, again, looking at is the question of the extent to which the ICC is able to realize the lofty aim and goal of engaging the victim population. And because I think it's important to highlight some positives, I want to stress that there are areas where they have positively engaged. And so, for example, the opportunity that the ICC provides, which is unprecedented amongst international tribunals, for victims to participate in proceedings, is a step in the right direction. The ICC has several organs that are dedicated to victims' rights and victims' issues, in particular, the Office of Public Counsel for Victims, the Victim Participation and Reparations section, and these have a particular mandate to engage victims. And we're seeing increasingly at the reparations phase that that is key, that you have structures in place to engage with victims, but that you also have processes that the victims are able to understand. By the time you get to reparations, this becomes even more important simply because the proceedings at the ICC take so long. The average victim who has applied to participate 10 years ago, for example, in the case of Mr. Bemba, may not actually get to a reparations phase until many years down the road. So I think it's very important for us to look at all of the factors from a victim perspective. And who are we talking about when I talk about victims and affected communities? We're talking about a diverse group of persons and affected communities. So the victim in Africa, and Africa itself is to say Africa is a generic term, and it isn't. We are the victims in Uganda who are here waiting for a decision in the Dominique Ongwen case are very different from the victim in the Central African Republic, and definitely different from the ones in Georgia. Their commonality is that they have suffered harms that amount to international crimes. The question is whether the court is prepared and has tailored its engagement, its intervention, its approach to victims to reflect those diversities. And I know I seem to be skimming the surface. It has a little bit to do with the amount that I think we can say in this time, but I want to drill down just in one example before I allow some others to engage on this issue or others. The situation in Georgia, for example, the victims mentioned the fact that before the investigation was authorized, they had very little information. There was just not a sense that the court understood the importance of transitioning from working in an African context where they had been for so long to working in the Georgian context, which was a very different one. So I think some of the issues that we are seeing are both structural issues. There are issues of process. There are issues about how, that have to do with the training of the court staff. We're seeing issues that seem to be recurrent and that have prompted civil society organizations, now staunch supporters of the court, to say they think the court is in trouble.
Thank you for that, Lorraine. I mean, that is a very sobering assessment indeed of the ICC. Can I infer from that perhaps, and Stephen, this is for you then, with the importance of Article 17 and complementarity, do we then pivot and look at national systems? Is that where we're going now?
Well, there's that thing that people quite often say, that the future of international justice is domestic justice. And I think it really has to be, because it's so hard for the ICC to do very much. Ideally, it would complete 1 or 2 cases a year, while dozens or even scores of them went forward at the national level. That's what we in the ICC world call complementarity. But for complementarity to work, there really has to be 2 dynamics in operation. One is what I call sort of persuasive complementarity or defensive complementarity. That's the idea that this court is so strong that you don't want your leaders dragged off to The Hague, and the answer to that is to do it at home. But the court's got to be very strong and effective for that kind of defensive or persuasive kind of operation to occur. And then secondly, we have what Luis Moreno-Ocampo called positive complementarity, which is providing resources for broken national systems to do these very hard cases. Just to deal with them briefly in both senses, in the persuasive or the defensive area, maybe that has worked in Colombia. I think Colombia political leadership and people didn't want them to be scofflaws. And I think it substantially modified their peace plan and the expectations, eliminated the idea of probationary sentences, and it at least provided for house arrest for those that confessed, because they didn't want the ICC to take on the case. But that's really the only real example, I think, where that has worked. Kenya was just almost completely the opposite, because I think the Kenyan leaders were clever enough to realize that perhaps the ICC would be much less effective than a domestic system would be. Justice Waki called for a national or special tribunal, perhaps with some international staffing and assistance. That could have probably really taken on that post-election violence and put a lot of those political leaders at risk. The ICC, on the other hand, didn't have the capacity or the cooperation to do effective investigations or to protect its witnesses. It was willing to go along with no arrests, no possibility of detention, defendants checking in and out of trials like it was a hotel. And then it was possible to demonize the ICC with political supporters as northern or kind of neo-colonial justice. So instead of being the 900-pound gorilla that you really need for defensive complementarity, we had really a 90-pound weakling. While we're talking about will, and as Lorraine brings up today's commemoration of the victims of torture, I do have to say, as someone who worked in the U.S. government for 6 years on these issues, that this issue of will is obviously the key to the whole ICC U.S. dispute, which has been so much in the news, because that whole dispute could have been solved if the United States government had the will to conduct a genuine domestic investigation into torture by U.S. agents that was authorized at a high level by policy in 2002, halted in military custody in 2004, and continued for 2 or 3 years thereafter in these CIA black sites. We only have to look at the Senate Intelligence Report, 600-page summary of which, in a redacted form, was issued at the end of 2014, and there's a 6,000-page document that would be available for any prosecutor or special prosecutor that that dealt with this. But we didn't deal with that, and instead the response now of the Trump administration is this executive order authorizing sanctions, which, if they're issued, would also enable criminal prosecutions for anyone here, there, or anywhere who attempted to evade those sanctions, all based upon this preposterous allegation that this weak court that is strictly following rules the U.S. supports applying to every other country in the world is somehow a national security threat like Al-Qaeda. And responding with sanctions, frankly, the sort of things that are threatened, if they were done domestically, would qualify as obstruction of justice under the U.S. Criminal Code, Title 18, Section 1503, endeavoring to influence, intimidate, or impede the due administration of justice. I should note from my friend Doug Castle, recently retired from Notre Dame. He has a letter now signed by 157 people to the President, the Secretary of State. It's open for signature until 3 o'clock this afternoon, and it'll be issued formally on Monday after being sent later today. So I urge people to look up Doug and join that letter, particularly American lawyers, because we're speaking to our government. That's this will issue. It can be solved if there's the will, but getting that will really requires a strong support for the ICC and states that are willing to use their leverage to assist the ICC. I mean, we saw the success of the ICTY in the Balkans and charging 161 people and bringing 161 to justice was largely a willingness of states to provide their leverage. And that frankly hasn't happened. It's happening in a small way now with these 67 states that are pushing back against the US obstruction. But it needs to go much further than that. On this question of positive complementarity, capacity building, I'm frankly disappointed. I mean, there are capacity building efforts by lots of donor states, but they don't deal directly with Rome Statute crimes. They deal with drugs and thugs, with corruption, with independence of judges, with a lot of other issues. And if you look at where actually aid is happening on Rome Statute prosecutions, I think we have obviously some in Guinea and the Democratic Republic of Congo. We've got this special criminal court in CAR, which is frankly underfunded and understaffed. We had some help, though not much anymore, in Uganda with their International Crimes Division that's now doing Aquiello. But beyond that, I don't frankly see much positive complementarity going on. The one positive area, and people don't often see this in the complementarity context, is that third countries are stepping up to the plate. That's a subject for Catherine, who's working on documenting and consolidating the documentation from civil society and victims and others to turn into case files in the Syrian context, where I think, frankly, the evidence is better than we had at Nuremberg. And this is all leading to cases in third countries, like the trial in Koblenz, and there are many others that are coming forward. And I think this promises to perhaps deliver some greater will at the national level, perhaps challenging in Syria, but I've already seen that these extraterritorial cases on Liberia that have gone forward in 4 or 5 countries are actually creating pressure to do things at home. A little different than complementarity, more of the so-called Pinochet effect. But I think that's what's happening. You know, it's intriguing, and when we look at these third states, I was at the Assembly of States Parties side event where Catherine spoke in December, and people were talking about all the things that were happening in third states on Syria. And there was one ambassador from a like-minded pro-ICC country that actually volunteered at one point. He thought we were probably further along on justice in Syria than if the Security Council had sent the case to the ICC in 2014. So that says something about how the ICC hasn't lived up to the expectations that many of us had, particularly in helping build the will and capacity at the national level.
Thank you for that. I mean, so if I can then pivot and sort of forum shop in a way, if we're saying the ICC is problematic, complementarity is not quite working, then the question for you, Charles, is, you know, what about regional mechanisms? Is a African court with a criminal chamber an answer? And I think you'd need to unmute.
Apologies. Thank you so much, Priya, for that question. And thanks, of course, to ISIL and the organizers, in particular, Angela Mudukuti and Adejoke Babintin Ashe, for putting together a fantastic program under very, very difficult COVID-19 circumstances. Before I get to the question, let me make a preliminary remark in view of the conversation we've been having so far. In my view, and this is something that comes out very strongly in the program description for this particular panel, the ICC is and will continue to remain the anchor of the international criminal justice system. I see the ICC as not just a beacon of hope for justice for the victims of atrocity crimes, but the bright lighthouse of accountability for states that are navigating the difficult, dark, and stormy seas of impunity. Nonetheless, as the organizers also correctly pointed out, the reality is that the ICC system, as central as it is to the modern project of international criminal law, which dates back, let's not forget, to Nuremberg, was never designed to carry the accountability burden alone. For this reason, it is important, in my view, that international lawyers begin to have a serious conversation about how alternative mechanisms, such as regional and perhaps even sub-regional and hybrid courts and other mechanisms, Stephen just mentioned Catherine's work in terms of Syria. And of course, we could talk about Iraq and so on. All of these mechanisms could play a role in giving more justice for the victims of atrocity crimes. Thus, in my view, the timeliness of this conversation is not just so much that there are alarming threats and attacks on the ICC's independence, again, something that Stephen highlighted, but that in fact we ought to step back and think about the legal framework of the court itself and what it assumes would happen. And this is this famous idea that in the end, international criminal justice is supposed to be domestic. So turning then to your question, Priya, my sense is if you look at the landscape of international law, although it seems to have taken international criminal lawyers a little bit longer to catch on, it is now apparent that there can be a useful role for regional courts in the investigation and prosecution of atrocity crimes. There are many reasons for this, of course. Some are theoretical, some are more practical, and in a sense, some straddle between the two. I do not have, in the limited time that we have here, the opportunity to develop some of these arguments in an emerging literature, especially driven to some extent by African scholars who are engaging with the subject of regionalism and its potential place in international criminal law and the implications for the accountability movement. And of course, I do not want to leave the impression that I'm advocating here a ghettoization of international criminal law, so to speak. So for that reason, let me make a more kind of broad meta point about the place of regionalism in international law more generally, before I then speak a little bit to what we see happening in the African Union and the African space in terms of efforts to create a criminal chamber that would have jurisdiction not just over ICC crimes, but also transnational crimes or other crimes of particular resonance to Africa. And so on that meta point about regionalism, I want to highlight that in fact, regionalism is a familiar concept in international law, at least if you think of the post-World War II international legal order. This is something that's also very familiar to international relations scholars, which of course, international relations being a sister discipline for international law. And what you'll notice when you look at these two areas, international law broadly and international relations, is that you find that there are increasingly interesting regimes where the success of the regime itself is centered on the interstate cooperation and coordination that's happening among states at the regional level. There are many examples of this. We can think of the place of regionalism in areas as diverse as international economic law. We can think of international human rights law, and perhaps the oldest of this, the law of international peace and security. You will see that regional approaches were recognized as potentially playing a vital role in the international system. If you start with the UN Charter, you can see if you look at Chapter 8, even though it only has 3 provisions in Chapter 8, Articles 52 to 54, they speak to regional arrangements in those, the states speak to regional arrangements in those provisions. And regional arrangements are expressly said in Article 52, essentially to not preclude the existence of the UN itself, does not preclude the existence of regional arrangements or agencies for dealing with such matters relating to the maintenance of international peace and security as are appropriate for regional action. And when you add Articles 53 and 54, you essentially see elements of a symbiotic relationship between the regional arrangements and action at the international level, in particular as driven by the principal body responsible for the maintenance of the Peace and Security Council. Take the second example of international economic law. We know the broad idea here is to promote global trade between states and to have rules that are complementary with each other. But going back to GATT 1947, the so-called RTAs, regional trade agreements, are allowed under the GATT WTO system. Of course, we have the possibility of preferential trading arrangements between states in a given region, and essentially this could feed back into the mainstream. And you have Article 24 in particular of GATT that provide for this, and then Article 5 of GATT's in the services agreement that provide for this as an enabling clause. So by the time we get to 2016, the WTO itself says, at least in terms of its 164 members, whether they have bilateral trade agreements, large customs unions, or continental or cross-continental trade agreements, all of their members are working towards that. So my final example that now links us very closely to international criminal law is international human rights law. We all know, of course, this is the conjoined twin of international criminal law in the sense that both are focused on protecting individuals and promoting human dignity. What you find is a universal international human rights system that's anchored around the International Bill of Rights. We have a little bit of mechanisms for enforcement through the treaty body systems and so on. Obviously, the bulk of the work now is happening in terms of realizing the promise of human rights in the regional human rights courts and commissions that we see in Africa, Europe, and the Americas. So in the end, then, my point is, in terms of taking these three possible examples of regionalism in international affairs, from international economic law, international peace and security, and international human rights, is that maybe there's something we could learn in the area of international criminal law by being a bit more open-minded towards the idea of the place of regional courts. And of course, that brings me to a third point, which is essentially where I want to drill down a little bit. And this links very nicely to the idea of international criminal law as either being an international system or a domestic system. What we've seen in the last little bit, in the last 20 or so years, is that we are beginning to develop hybrids that cross the two. We already have decades of experience with the pioneer international tribunals. And obviously, in terms of the ICC, the way this has played out, and Stephen talked about this, is that complementarity was meant to give the first opportunity to the states parties themselves to do the bulk of the heavy lifting. In a sense, the best we can hope for is the ICC to step in and essentially do the greatest responsibility part of the scheme and develop things from there and dealing with the leadership and so on. So in the end, then what we see is states are taking this very seriously because we know that inaction, unwillingness, inability can link as the conditions for ICC to get cases to work at the regional level. And in practical terms, what this means then is we have to think about ways to have that positive or persuasive complementarity, as Stephen puts it, so that we can help the states to do the job at the national level. And African states, I think, have been a bit disappointed in this area, to the point that they're now looking at a regional mechanism in the so-called Malabo Protocol, where they basically adopted, in June of 2014, I believe, at the level of the AU Assembly. Now, while it's not yet in force, this instrument, it is a really creative document. Essentially, it hasn't been looked at very well in the sense of the context in which it emerged about an Africa ICC tension. But if you go beyond that and look at the instrument itself, you see a lot of innovations. The first thing you would notice is that it has a strong tripartite jurisdiction over general, criminal, and human rights matters under the same roof with separate sections of the court dealing with these different issues. So in a sense, the issue of economies of scale. Secondly, for the international criminal jurisdiction, it has what I call the ICC plus jurisdiction. So essentially, you have jurisdiction over Rome Statute crimes, but also other crimes of particular concern to African states. So things like mercenarism, trafficking in hazardous waste, unconstitutional change of government, and what have you. And then, of course, it has an additional layer of corporate criminal liability that well goes beyond the ICC system in terms of criminal responsibility. So if you think about conflict diamonds, conflict cocoa, conflict oil, and other resource-driven conflicts, you could see that the African scheme that they propose to have would essentially target the people who really benefit from the depredations and the impact of atrocities on human beings. Ultimately, the last point I would leave you with at this stage is to talk about how and whether this is consistent and complementary to the ICC system? I would say that it is. And in fact, African states have put at one point a proposal that reflects their view that in fact, this kind of system will be complementary to the ICC. Kenya made a proposal in November of 2013, where basically calling on African Union resolutions, Kenya suggested that it might be better for the Rome Statute preamble to essentially provide expressly in a way that acknowledges the role of national criminal jurisdictions as being related to regional. So the language they propose would be emphasizing that the International Criminal Court established under this statute shall be complementary to national and regional criminal jurisdictions. What is interesting is the argument that Kenya made at the ASP, which did not get any pushback from other states, which was that they feel like complementarity is already possible to accommodate this, but that they want to sufficiently recognize regional criminal mechanisms by making that change. That proposal has not matured into any amendments, but my point is to say that at least we see in the African region, there's a push towards looking for alternatives. And I think international criminal law would be the better for it, especially if African states put the political and then that will that is necessary to give actual meaning to the Malabo Protocol. I'll leave it at that. Thank you very much.
Thank you. And I think sort of picking up from, the point that you've made as well as Stephen's made, and coming to Catherine, what is the role of the mechanism in this constellation of the ICC, this discussion of regional courts? Where do you see it? And what are the strengths and weaknesses? So it's quite a big question.
Indeed. Well, thanks a lot, Priya, and let me thank the American Society of International Law for giving me the opportunity to be part of this fascinating discussion. So how are we different from other justice actors? Well, I think we're not a court to start with. So probably if we understand justice actors in the sense of prosecutors and courts doing justice, well, we're clearly not in that category. We can't adjudicate crimes. But I think if we go back to the reason why we were established in the first place, that is a veto preventing the referral of the Syria situation to the ICC, you will understand what we are, in fact. And after this veto, which no doubt, these vetoes, because there were several, which no doubt were setbacks for the survivors of the horrific crimes alleged to have been committed in Syria. In fact, as often after setback, there is an opportunity that arises. And in fact, the very innovative mandate that the General Assembly decided to give the mechanism when creating it has been extremely interesting and has opened a new era, I would say, of support to accountability. So let me explain what we are, in fact, since we are not a court. Well, we've been described as having a quasi-prosecutorial function, and this in spite of not being in a position to issue indictment ourselves. So the reason for that is because the mandate is really to assist the investigation and prosecution of core international crimes committed in Syria since March 2011. And what does it mean? It means that we are really tasked with doing the preparatory work that is needed to permit to bring to justice those responsible for those crimes. As Stephen mentioned, of course, there are at the moment national jurisdiction outside of Syria, essentially in Europe, but not only, that are investigating crimes committed in Syria, making use of different forms of jurisdiction. And these are extremely important opportunities, tangible signs of justice. So I'm certainly not wanting to disregard those. But when you look at the scale of crimes committed in Syria, clearly we have to look at a more comprehensive form of justice. So as we support those efforts, and I will explain how we do that, we need at the same time to keep an eye on the longer term justice for when other forms of justice, maybe more international forms of justice, and the ICC could be part of that, I know we will come back probably to that later, well, then we need to make sure that the work has been advanced enough to facilitate those processes too. So it's really short-term, long-term. Now, how can we do that? By applying criminal law standards, by applying a criminal working methodology, so that the work we do is really relevant to those criminal law justice actors. And that's certainly what distinguishes us too from attribution mechanism, if I want to put it this way, because those are clearly meant to document and make public and attribute the existence of violations in certain areas. We're familiar with the work of the Commission of Inquiry, but we're also familiar with the work of the JIM, for instance, the Joint Investigative Mechanism for chemical weapons. But at the same time, we are meant to prepare case files. So that's a very different work, a work that is towards making public allegations and reporting. We are doing the groundwork that will facilitate, and that is currently already facilitating criminal justice initiative. Our main weakness is certainly this incapacity to deliver justice on our own. Instead, we are building blocks towards a more comprehensive justice. As I've said, we're facilitators, we're enablers. That may not be as sexy as a court of justice, but that is actually quite useful. And it may sound paradoxical, but I'm certain that we're actually able to turn this weakness into what is our strength, which is our capacity to adjust to the needs of the various type of jurisdiction with different legal frameworks, and to shape the type of work that we're doing to be really relevant and useful to their to their efforts. So we're doing exactly that already at the moment. The national prosecutors and the courts that turn to the AAAM are, as I said, making use of universal jurisdiction or extended forms of extraterritorial jurisdiction, and they come with requests for assistance. We've already received over 60 requests, I think exactly 64 requests for assistance from such jurisdiction from 11 different states. And very briefly, I'm conscious of the time, very briefly, how do we respond to such requests at the moment? Well, we run searches into the central repository of the evidence and the information we collect, either from other entities or directly making use of our investigative capacity. And we provide either pieces of evidence, but also analytical work that we developed for these jurisdictions. We also can pursue leads. We can provide expert evidence. We have decided in consultation with these prosecutors that are having ongoing investigation, that developing specific build evidentiary module, if I can put it this way, to assist them in the prosecution of war crimes or crimes against humanity, is something that is a very great assistance to them. So just to give you an example, we are developing a module that is setting out the contextual requirements to support prosecution of war crimes at the moment, and this will be able to benefit more than one jurisdiction, in fact.
Thank you very much for that, Catherine. That was a very comprehensive understanding and overview as well of the mechanism. And I think, for a lot of people, the focus has been on the courts. And I think now we definitely need to look more seriously and take into account the work the mechanisms are doing. We'll move to our sort of second session, and we'll keep the responses briefer now, because we do want to try to get to also the new changes and challenges that are coming up. So, if I can request all the speakers to give me fairly abbreviated answers, and then we'll go to a larger discussion as well. So in terms of accountability towards victims and survivors of gross violations of human rights and IHL, Lorraine, for you, I mean, I'll ask you sort of a little bit of a tough question, which is, for years, the OTP or the ICC has been accused of targeting Africa. And now we see a lot of the preliminary examinations are actually outside. And there seem to be, bold steps in terms of including the Afghanistan investigation. So what, in light of these actions, what are the challenges that you would see as sort of most important for the court? Lorraine, the unmute, please.
I think the challenges that we are seeing are, it's interesting. We don't even have to think too hard because the court is facing it right now. It's facing incredible pushback. We have seen in several situations that the court has opened, while the court was investigating in Africa, there was pushback. We saw, the pushback from the African Union, the decision, for different reasons, calling for African states parties not to engage. We saw that. We've seen pushback in the form of some African states deciding to withdraw. And for example, Burundi deciding to withdraw, and at one stage, South Africa was considering withdrawal. So there has been pushback, and that is something that the next prosecutor is going to have to deal with, the fact that when decisions are made that are unfavorable politically, there could be very strong pushback in the form of decisions to withdraw. And this is in relation to states parties. But beyond that, you have pushback in another form. And I think this has been alluded to already by Stephen, the very strong pushback and threats. And I would say that, the denigration of the court, the way it's being described as a kangaroo court, that kind of pushback that is going, and threats that are tangible against the court, against the very fabric of the court and the institution it represents, that is also an existential threat that the ICC is going to have to deal with. There is another major issue that I don't think we should overlook in this discussion, and that is the threat in relation to cooperation. The reality is that the court depends on cooperation in order to function effectively, and this is often forgotten in these kinds of discussions when we're talking about whether the court is functional or not. It depends on cooperation. And so, for example, we know that in the Kenyan context, the prosecutor had to end the case because, at least one of the reasons was because of the failure of the state to cooperate. So there are several issues that I think the new prosecutor, any incumbent prosecutor, is going to have to be prepared to face. And this is not something that's new, but it's a reality. And the last one, I think it's well known, the lack of resources. In her strategic plan for 2019 to 2021, the Office of the Prosecutor said, I'm going to have to prioritize my investigations because we simply do not have the resources that we need to do everything that we need to do at the same time. So that is the very, very abbreviated response, and I'm sure it will spark additional discussion.
Thank you for that, Lorraine. I think we've come to a point where we've got a little bit of time still to delve into some of the current challenges. So, with your liberty, I'm sort of going to move to a few questions that we've got from the audience as well, but sort of the larger perspective on the court. And if I can put all of y'all on the spot with specific questions, I think, let's do that. I think for Stephen, I mean, just to paint the picture, at this point, we've got an independent expert review ongoing. We've also got judicial nominations. We've also got the election of a new prosecutor. So 2020 is a big year. Stephen, if you could tell me your approach or what impact the recent executive order 13928 you think is going to have on the court and next steps, I think that would be very helpful.
Well, obviously, we want to see that order minimized. We want to see it withdrawn. I frankly hope there's litigation against it because it's going to impact in America on people that are working with the court and want to assist victims in pursuing justice, and have been leaders in this area, various human rights groups that work with victims around the world. So I hope that it's something that is knocked down or withdrawn certainly after the next election. But meanwhile, in terms of the ICC itself, I mean, this whole expert review, a key part of it is not within the expert review, is state cooperation. That was something left out, and I think that's where really efforts need to be made. States providing the leverage, as they are to some extent against this U.S. action, but also to get cooperation and arrests and to build investigations. Within the court itself, I think there's no question that investigations need to be strengthened. And of course, a lot of that involves building a better partnership with civil society and groups that are doing the kind of documentation that Catherine's working with. There's criticisms in the past with intermediaries, but I think we have to find ways to maintain high standards. The court can't do it all, and these cases need to be stronger. A lot of interest in the court being more effective and speedier in its trials. I'm part of an ABA criminal justice standards project that involves people from the defense and the victims community and others. But a key part of that is the management of the courtroom and having good people elected judges who have experience in these areas. And one of the reforms that I see as essential is the appointment of a pretrial judge, not the pretrial that engages in confirmation, but more along the lines of what we've seen at the ICTY, really getting in and trying to narrow the issues to the real fighting issues and narrow the testimony, focus the trial on the things that matter. A great deal of what the court ends up fighting over, whether it was a widespread or systematic attacks in Cote d'Ivoire, for instance, which I think was unquestionable, turns out to take up most of the time. They need to focus on these issues about the individual criminal responsibility. And I think it's important for the court to be effective for the reasons that I just said earlier. If it's going to help motivate complementarity, it's going to have to be a court that people don't want to go in front of, would prefer to have things at the national level.
Thank you. Charles, if I could ask you, what do you think, is 2020 a sort of seismic year for the court? Is this, this is what a lot of people sort of say, and is this really a pivotal year where it's make or break?
I would agree that it is an important year, although I would caution that we don't overburden the incoming officials, in particular the prosecutor, with too high an expectation of change and perhaps too quickly. My impression is that it is pivotal because the independent expert review process is an opportunity. This is a process very similar to something that we saw in the ad hoc tribunals. There was a review process in that case by Justice Hassan Jallow in the context of the ICTR. There is a famous Kasesi report in relation to the Special Court for Sierra Leone. And essentially, I see it as important because it's an opportunity for an external voice, so to speak, to come in and have a big picture look at the entire system and how the court is doing. And obviously, the complexity of the ICC system puts this on a completely different scale. But I do believe that there's an opportunity there for the court, especially if the states parties step up and drive the proposals that come out so that they actually take ownership of the process. Obviously, in this space, I could make a point about the importance of the African experience. And I notice, of course, that there are prominent African jurists on the independent review panel. I think that is excellent at a symbolic level. I think it signals that the African concerns will be taken seriously and that Africans are not just the subjects of the court's cases, or as one unfortunate remark by, I think, a Western judge, that Africa is there supplying the cases, that Africa is a partner in this process. And my third point that links to that is that, in fact, because Africa has done a lot of experimentation over the last little while, unfortunately, because of the atrocities that we've seen on the continent, if you think about everything from apartheid to the Rwandan genocide to my home country of Sierra Leone and so on, Africa has a lot of experience to share with the ICC. Obviously, it is the place where a lot of the ICC cases have come from, both in terms of the situations, but also the individual cases. It has been the subject of the referred situations, both Sudan and Libya, from the Security Council. So I believe that one of the potential benefits is that Africa could share its experience with how we could improve the system. One of the blind spots that concern me a little bit is the impact of COVID. And I'm not certain how much African civil society and African governments are engaged in the process of review. I believe that those experiences could be fed through, and that the recommendations may well be in a place where in the new coming prosecutor confronted with a report, they at least would have somewhere to start to think about complicated issues like, for example, the OTP policy paper on interests of justice. How do we sequence peace and justice? I mean, it cannot always be that when the ICC gets involved and then all other alternatives are off the table. And obviously, Colombia gave us a hopeful sign that the ICC will listen in the right circumstances. And I believe that that is the right direction. So I see this as a moment of opportunity with caution, provided that we get good results out of the process. And I hope that the court embraces this so that it doesn't seem as a pushback. It doesn't push back at the recommendations. There was a tendency in some of the ad hoc tribunals for that to happen. It will require the states parties to jump in and make sure that we take on board the recommendations.
Thank you for that, Charles. Catherine, one sort of last question for you, which is, do you see the mechanism evolving along with some of these, the International Criminal Court and also the questions around domestic jurisdiction of national crimes? Or is this a sort of separate mechanism that it will evolve on its own? And are you getting the support that you need as well? And the unmute.
Here I am. Well, it could seem from the outset that these are two separate spheres that don't intersect, but that's not the way I see it. I think, well, first of all, those discussions surrounding the ICC are extremely important for us because of the role that the ICC is to play in the international criminal framework that we have. And as I said earlier, I really don't see with the Syrian situation a solution that would be, to paraphrase Charles, either national or international. It has to be a bit of both, and probably even potentially regional as well. But obviously for us, we, as I indicated at the beginning, I think these perspectives are probably longer term for us. So we've, for the reason that we know the veto, but also the fact that the ICC does not, as far as I understand, exercise jurisdiction for even smaller part of the Syrian situation. But we are making work which will enable us, the day those opportunities arise, to be in support. And I think it's not just a matter of making our central repository available to a court like the ICC or an ad hoc tribunal if it were to be created. It's not just about handing over cases. It's also making at the disposal of a court, an international court, what we've organized, all the analytical work that we do as part of our structural investigation. And that is something that I think any prosecutor would dream to have when taking a new situation, having a lot of work already done, identifying the main actors, identifying the functioning and the role of the structures that have been involved in the commission of crimes, having already an assessment of the main patterns of crimes, and not just an assessment, but the underlying material and the analytical work related, and covering dimensions that are often overlooked in past criminal accountability experiences, such as sexual violence and gender-based crimes and gender more generally. So we have this unique opportunity of integrating that lens into the work that we do from the outset, and that's a great benefit for us. You're talking about support, and I think in terms of support, I mean, of course, we need support from three different levels. I would say first, political support, financial support, and technical support. And I'm thinking here more of support from state or other international organizations or entities. And when we started, we, of course, were faced with a lot of opposition very strong from a number of states. But the reality is that we also generated a large majority of states that wanted accountability, that were not going to give up after the vetoes, and that were clearly aware that sustainability of peace in Syria, we don't yet have peace, but if and when we get peace, sustainability of that will require accountability. So in fact, I think that we haven't had difficulties generating support. Yes, I'm going to wrap up. Sorry. We have been able to obtain the financial support in the very early years via voluntary contribution. We've been able to then have our needs entered into the regular budget at the end of last year by a vote of the General Assembly, and the technical support, more is needed, that's clear, but we're receiving technical support in the form of cooperation agreements, in the form of access to evidence that national authorities obtain, and in the form that's an area where we need even more support, in the form of being able to provide protective measures to the witnesses that interact with the mechanism. I will stop there.
Thank you very much. Unfortunately, this is all that we have time for. I mean, I really feel that we've just about scratched the surface and we could really go on for a lot longer. So at this point, I will just say that, are we looking at a bright lighthouse of accountability? Are we looking at an older teenager? We're looking at new mechanisms, complementarity, regional courts. So we've got a whole lot of things to discuss in the future. And I can only thank the panel and the American Society of International Law for really a fabulous discussion and a starting point. And I hope we can continue the discussion further. So thank you very much. Round of applause to all of you.
Thank you very much, Priya.
Thank you, Priya.
Thank you.
And colleagues.
Thank you, Priya.